Attorney Zach Bailey with the Marc Lopez Law Firm to talk a little bit about some frequently asked questions we get about domestic battery cases here in Indiana.
What is domestic battery?
Domestic battery is typically defined as someone who touches another in a rude, insolent, or angry manner, and that other person is a family or household member. Now, family or household member has a few different definitions, but essentially, if you're living with someone, if you're in a sexual relationship with someone, or if you're related to them, typically through blood, they will qualify as a family or household member.
What are the potential penalties for domestic battery?
A standard A misdemeanor domestic battery in the state of Indiana carries a penalty of up to 1 year in jail or prison. So that 1 year sentence is the maximum for an A misdemeanor. The minimum penalty is 0 days in jail and 0 fine. So it can be enhanced based on prior convictions and things of that nature, but at its core, domestic battery as typically charged is charged as an A misdemeanor.
What is a no contact order?
A no contact order is exactly what it sounds like. It's a person you are prohibited from having contact with. Now, it's not just you. You also can't have anyone you know reach out to that person on your behalf. So it's very important to abide by that no contact order, because if you don't, new charges can be filed for invasion of privacy, which makes everything much more difficult with your case.
How can a no contact order impact my family?
No contact orders can be very difficult for a family. A lot of times we see in these domestic battery cases, maybe the man is charged and his wife is home with the kids and saying, please, I need to have him home, but he can't come home because that no contact order is in place, protecting her, protecting the kids, something like that. So a lot of times these no contact orders in place are keeping families apart, and they're designed to stop violence. They are helpful in what they are designed to do, but sometimes it goes beyond that and they become more of an issue for the people involved in the case. And someone who's a victim on the case is victimized even further because maybe they need that person to help support the family, paying the bills, helping with the children, things of that nature. And so it can have a tremendous impact on the family.
What is a protective order?
A protective order is similar to a no contact order. So a no contact order is issued out of a criminal case. A protective order comes out of a civil case. They function in very similar ways where they protect one party from another party. So just like a no contact order, if a protective order is issued, you cannot have any contact with that person. It comes from typically a civil filing for a protective order or a criminal filing for a no contact order, but they function the same way.
What happens to my firearm rights if I am convicted of domestic battery?
So if you are convicted of a domestic battery charge, you will have a domestic violence finding against you. And what that means is you are prohibited from owning a firearm. So even if the case is done, you're off probation, even if you were never charged with a felony, that domestic violence determination will keep you from having a firearm.
Can I get my firearms back after a domestic battery conviction?
Now, there are ways that we can get that restored. If you are done with your sentence and a certain amount of time has passed, give us a call and we can file to remove that domestic violence determination and restore your firearm rights. That's a very important step. It's something we look into when we do expungements as well, because if we expunge a case before we restore your firearms rights, even though your whole background has been expunged, you would still be ineligible to have a firearm. So it's important to get that domestic violence determination removed.
What is the discovery process?
So the discovery process in Indiana is automatic. You may hear about attorneys or people in other states talking about filing for the discovery. You don't have to do that in Indiana. Discovery is automatic. Once a case is filed and once there are appearances on the case, the state will begin turning over the discovery or evidence that they have on the case to us. This includes paperwork, photographs, videos, 911 calls, anything like that. So we will get that discovery automatically, and that typically happens within a month or two after that initial hearing date. It will not happen before the initial hearing date. And that's something a lot of people ask questions about. Why haven't you started working on my case? We don't usually get that discovery until after the initial hearing date, but usually before that first pretrial conference. And that's when we can begin looking into your case and figuring out how to build a defense.
What is a plea bargain?
So a plea bargain is usually admitting to one or more of the counts against you. Oftentimes they would dismiss other counts in return. And the main benefit to it is that you get a known outcome. If you take a case to trial, you run the risk of the judge sentencing you if you are convicted, and it's out of our control at that point. We can make arguments, but we don't get to agree to a sentence anymore. So typically for domestic battery, if it's charged as an A misdemeanor, the maximum penalty is 1 year. The judge could sentence you all the way up to that 1 year in jail, which would be the maximum sentence. On a plea agreement, maybe we could reach an agreement for probation, something along those lines. So even though you're admitting to the charges against you, you know what the outcome is going to be, and we always want to prioritize making it something that you can live with, something that is not going to affect you in any tremendous way. Now, the cons of of a plea agreement, or you are admitting guilt to a charge. You would have a criminal record as a result. And so a lot of people don't want to admit guilt, and they find that as a reason to not accept a plea. We will never tell you you have to accept a plea. That's up to you. What we will do is give you the best options we possibly can. We'll give you the lowest plea offer we can negotiate, while also giving you an honest assessment of your case for trial so that you can make the best determination for you.
What happens if I take my case to trial?
If you take your case to trial, it'll either be in front of a judge for a bench trial or in front of a full jury for a jury trial. Reach out to us and we can talk about your options for a bench versus a jury trial. And it's important to do it early on in your case, because if you're charged with a misdemeanor, that jury trial, we have to file for that early on, or your case will automatically be set for a bench trial. And what happens is the state will present their evidence. They will go with their witnesses. They will present their entire case first, and then we have our chance to respond. And that's like what you see on TV, the big courtroom, the grand trial. It's usually 1 to 3 days in length for the trial. And then at the end of it, if you're acquitted, then your case is done. You are done with that case. There will be no sentence. You are found not guilty. If the judge or jury finds you guilty, then you would go to that sentencing phase where the judge would determine what your sentence would be. So again, at that point, the sentence is out of our control and up to the judge.
How can a domestic battery charge impact my future?
So any criminal charge can impact your future. Domestic battery can have that impact on your ability to have firearms. It can have an ability on parenting time if there's a family law proceeding going on. If a domestic battery determination can lead to a ruling that parenting time would have to be supervised. So it can have a tremendous impact, and we'll want to make sure we talk about the possible ramifications of it. Now, if it's domestic battery charges a felony conviction can have even greater impact on you. And so it's important to talk about possible consequences of a conviction before entering into any kind of agreement or before deciding whether or not to go to trial.
How can the Marc Lopez law firm help me fight my domestic battery charge?
So we can absolutely help you fight domestic battery charges. We are never going to push a plea agreement in front of you and tell you you have to sign anything. That is your decision to make alone. What we will do is prepare the case for trial. It involves interviewing witnesses, doing depositions, doing whatever it takes to build the best defense for you so we can present you your options. We will always work with you to try to find an outcome that will work for you and your future. We certainly don't want to agree to something that will impact you long term.
What makes the Marc Lopez law firm different from other law firms?
The number one complaint we get about other attorneys is that people cannot get in touch with their attorney. And so we want to make sure that that's not an issue with us. You will have our personal text number, our personal email addresses, as well as our personal phone conference link, all the same for our paralegals, so that you are always able to get in touch with us when you have questions. I never want someone to say, I don't know what's going on with my case, because that's not fair to you. This is the most important thing, or at least one of the top few going on in your life right now. And we want to make sure you have all the answers to all your questions. So we make sure we are available to you so that you can get your questions answered. Now, it won't always be the same day. We're in and out of court. We're working hard, but that's why that phone conference link is important, because that sets a time on our calendars where we have time reserved for you. If you have any questions about domestic battery charges in the state of Indiana, give us a call. 317-632-3642. Remember to always plead the fifth.